Have you ever wondered how criminal defense attorneys fight for their clients using evidence? One key element that can make or break a case is discovery. It's a vital part of the legal process that ensures both the defense and prosecution have access to crucial information before a trial. In this video, we'll break down the critical aspects of discovery and explain why it's so important. Whether you're a defendant, a concerned friend, or simply curious about criminal law, understanding discovery can help you appreciate how an attorney builds a solid defense. Stick around to uncover how this often overlooked process is essential for a fair trial. What is discovery? A quick overview. Discovery is the formal process by which both the defense and prosecution exchange evidence before trial. In criminal cases, this means the prosecution shares information that could be beneficial to the defense, such as witness statements, evidence, and police reports. It also involves the defense sharing its own evidence, including witness lists or expert testimony. Discovery aims to prevent trial by surprise and ensures each side has the information needed to prepare their case thoroughly. Without it, a defendant could face an unfair trial, with unknown facts coming to light only during the trial, jeopardizing their defense. The purpose of discovery: leveling the playing field. The core purpose of discovery is fairness. It ensures that both the prosecution and the defense have access to the same information, preventing one side from having an unfair advantage. Discovery prevents trial by ambush, where evidence or witnesses are introduced at the last moment, leaving the other side unprepared. By requiring the disclosure of evidence, the process allows both parties to prepare their arguments and know what to expect in court. This transparency is essential for ensuring a fair trial and upholding the constitutional rights of the accused, especially the right to confront evidence. The right to discovery, a constitutional right. In the U.S. legal system, the right to discovery is derived from the Sixth Amendment, which guarantees a defendant's right to a fair trial. This constitutional right ensures that a defendant can prepare a meaningful defense by reviewing the evidence against them. It protects the principle of due process, meaning the government must provide access to the same information they plan to use in court. Failing to provide this access can violate the defendant's rights and lead to a mistrial or dismissal of charges. Discovery is thus not just a procedural formality, but a foundational safeguard in criminal law. What can be discovered? Key items in the discovery process. During discovery, various types of evidence can be exchanged. This includes police reports, physical evidence, witness statements, and recordings such as 911 calls or video surveillance footage. The defense has the right to request all relevant materials that may support their case or challenge the prosecution's evidence. For example, they may ask for the list of witnesses the prosecution plans to call, as well as any exculpatory evidence, information that may exonerate the defendant. Discovery is an essential process that ensures all evidence is scrutinized and analyzed before trial, giving the defense a fair chance to challenge the prosecution's case. The types of discovery: physical, documentary, and testimonial evidence. Discovery covers three primary types of evidence: physical, documentary, and testimonial. Physical evidence includes items such as weapons, drugs, or any objects linked to the crime. Documentary evidence could be emails, photographs, or official records that are relevant to the case. Testimonial evidence refers to statements made by witnesses or experts who may testify at trial. Each of these categories serves a different role in building the defense's case. By thoroughly reviewing these types of evidence, a defense attorney can identify weaknesses in the prosecution's arguments and prepare an effective strategy to challenge the case in court. Depositions, a tool for understanding witness testimonies. Depositions are a powerful tool during the discovery process, particularly when it comes to understanding witness testimonies. A deposition is a sworn, out-of-court statement taken from a witness, often conducted by the defense attorney. These statements provide valuable insights into what witnesses may say during trial and can help uncover inconsistencies, biases, or weaknesses in their accounts. Depositions are also crucial for preparing for cross-examination. They allow defense attorneys to plan their strategy in advance, ensuring they are well prepared to challenge the credibility of a witness or highlight flaws in their testimony. Discovery deadlines. Timeliness is everything. Timeliness is key when it comes to discovery. Both parties must comply with strict deadlines for sharing evidence, and failure to do so can have serious consequences. If discovery is late or incomplete, It may delay the trial or, in extreme cases, result in sanctions against the non-compliant party. Timely exchange of information allows both the defense and prosecution to adequately prepare, ensuring that neither side is caught off guard. Missing deadlines can also hinder a defense attorney's ability to fully investigate the evidence or interview witnesses, potentially jeopardizing the outcome of the case. The prosecutor's duty: full disclosure of evidence. Under discovery rules, the prosecution is required to provide full disclosure of all evidence related to the case. This includes both inculpatory evidence, which helps prove the defendant's guilt, and exculpatory evidence, which could favor the defense. Prosecutors are legally bound to share any evidence that might exonerate the defendant or reduce their potential punishment. Failure to disclose such evidence is considered a violation of the defendant's constitutional rights and can result in a mistrial or even dismissal of the charges. The prosecution's duty to disclose ensures that the trial remains fair and just for the defendant. What happens if discovery is withheld? Withholding discovery is a serious violation of the legal process. If either side fails to disclose evidence, especially exculpatory material, it can undermine the integrity of the trial. When the defense believes discovery has been improperly withheld, they can file a motion to compel the prosecution to release the evidence. In some cases, if the court finds that evidence was intentionally withheld, it can impose severe sanctions, including dismissing charges or excluding certain evidence from trial. The defense must remain vigilant in ensuring that all required information is disclosed and available for review before trial begins. Why discovery is crucial for building a defense strategy. Discovery plays a central role in shaping a defense strategy. By reviewing the prosecution's evidence, the defense can identify potential weaknesses in the case, including inconsistencies in witness statements or gaps in the evidence. Discovery allows the defense attorney to build a strategy around these weaknesses, preparing for cross-examination or even challenging the evidence's admissibility. Without full access to discovery materials, the defense would be unable to mount a well-informed challenge, leaving the defendant vulnerable to conviction. Discovery essentially provides the foundation upon which a strong defense is built, ensuring that the defendant's rights are adequately protected. Discovery violations. When can you challenge it? Discovery violations can occur when evidence is not disclosed or when it's provided too late. If the defense believes the prosecution has failed to comply with discovery rules, they can challenge this in court. Common remedies for discovery violations include filing a motion to compel, which asks the court to order the prosecution to provide the missing materials. In more extreme cases, a judge may dismiss charges or impose sanctions. By understanding when and how to challenge discovery violations, the defense can protect the defendant's rights and ensure they have access to all relevant evidence before trial. The importance of an experienced defense attorney. An experienced criminal defense attorney is crucial when navigating the complex world of discovery. They understand the rules and deadlines governing the process and know how to use discovery to the defendant's advantage. An attorney can identify key pieces of evidence that may help build the case, request depositions, and challenge any violations in discovery procedures. With the right legal guidance, the defendant is far more likely to secure a favorable outcome, whether that means getting charges dropped, negotiating a reduced sentence, or preparing for trial. The value of skilled legal representation cannot be overstated in ensuring justice is served. To sum it up, discovery is a cornerstone of any criminal case. It ensures fairness, helps uncover vital evidence, and allows the defense to build a solid case strategy. From understanding the different types of evidence to knowing your rights, discovery is something no defendant should overlook. If you found this video helpful, don't forget to like, comment, and share this video. For more tips on criminal defense, make sure to subscribe to Criminal Defense Attorney Tips. Stay informed, stay prepared, and remember, knowledge is power when it comes to protecting your rights in the legal system.